that. And for those reasons, the state would ask you to affirm the convictions.
Okay. Any questions, Ms. Chalmers?
Thank you.
Thank you very much.
I have no.
Okay, thank you all very much. I appreciate your straightforwardness today, and we will take this matter under advisement and the excellent briefs that were written and go from there. Thank you. Okay, the next case we have is Peyton Taylor, appellant versus estate of Bryan Pearson, by and through Joshua Becker, special administrator. The parties state their appearances, please.
Good morning. May it please the court. Dan Kopp on behalf of the appellant and plaintiff.
I'm sorry, your name is what?
Dan Kopp, K-O-P-P.
K-O-P-P. First name Dan?
Yes, ma'am.
And were you on the briefs?
I was not. I entered my appearance.
Okay, can I just get your bar number? That's all. My administrative assistant is going to be typing this all up.
Could I get that for you?
Sure. Oh, sure, sure. Right. You can get it when we're on the next case if you want. I just want to make sure. So it's Dan Kopp, K-O-P-P, for the appellant Peyton Taylor.
I have it.
Okay.
So it's 28354.
354? Okay, great. Thank you.
Daniel is.
Oh, Daniel is the formal name. Okay.
Daniel Adam. It's a double biblical name. So.
Okay, got it. Thank you. And for the appellee? Yes. Okay. Thank you very much. And did you wish to, Mr. Kopp, did you wish to reserve any time for rebuttal?
Yes, 3 minutes, please.
3 minutes. You've got it. Thank you. You can begin. Yeah.
May it please the court. Good morning. My name is Dan Kopp and I represent the appellant and plaintiff Peyton Taylor. We're here today to ask the court to reverse a sua sponte judgment that was entered against Ms. Taylor in violation of her constitutional right to due process and contrary to undisputed facts established by defendants' binding admissions. This court should reverse the district court's January 17th, 2024 judgment and remand this case for a new fair trial. Ms. Taylor was promised and is constitutionally guaranteed for two primary reasons. First, the district court's sua sponte judgment violated Ms. Taylor's due process rights guaranteed under both the Kansas and United States constitutions. And second, the judgment itself was clearly erroneous as it found no fault when appellee and defendant vicarious admissions through counsel conceded he was negligent and his negligence caused Ms. Taylor some measure of compensable damage. But before going into those 2 points, as a threshold issue, the January 17, 2024 judgment should be considered null and void as an exercise of judicial authority beyond what is vested in district courts. Plaintiff's counsel has not found any statutory authority, Supreme Court rule, or case law that allows for a district court to do what it did here. There was no notice, there was no pending motion, there was no request by the parties. And there was no hearing on the dispositive issues and the issues taken up by the court in its January 17th order. This would then lead to a dangerous precedent on the scope of judicial authority. Right now, we have pretty basic strictures in which district courts do things when motions are pending and there is notice that must be given and guaranteed under our due process rights. Here, we had none of those things. And the problem that this case could present is a precedent that allows district courts to dispose of cases or craft escape routes when they just don't like cases. And they can consider any of their prior orders interlocutory. I mean, the most extreme example would be you've got a 4-week trial and you had previously denied a motion for summary judgment. Gosh, I really want to go to Maui or something like that. And then they decide, well, I'm going to consider that prior denial interlocutory. I'm going to reconsider it. I know the facts. Therefore, I'm going to grant summary judgment. Case closed. So that's the precedent that we're trying to avoid here. And that's the true importance of this case. Beyond the injustice that Ms. Taylor has suffered, the true importance of this case is, what is the scope of judicial authority? Do district courts have to have pending motions before they reconsider interlocutory orders? Do they have to provide a clear and adequate notice to the parties before they reconsider prior motions before they take a case up on the merits. And unfortunately, that is not what happened here. And the record is full of what can only be characterized as statements by the district court showing a disdain for bench trials and for this case in particular. And that should not stand. And that's why we ask that this court, if you find that this act, this surprise judgment was beyond the scope of judicial authority, that judgment should be considered null and void, and we should remand this case back for a new trial just based on that issue alone. Turning to my first point, which is the due process violations that Ms. Taylor had suffered. Again, we got to look just at this January 17th, 2024 judgment. And there was no notice, nothing was provided to either parties that there was going to be a reconsideration of the motion for new trial or the motion to strike Dr. Wood.
So that's what leads me to my first question. So what due process would have been appropriate to conduct the bench trial, to notice up the fact that he was considering doing this? What could the court have done to satisfy the due process concern?
Yes, Your Honor. So with taking up this case and reconsidering these motions, the due process would have been noticed that he was going to take this case up so that Ms. Taylor would have an opportunity to be heard, potentially briefing on these issues, and a hearing on, one, are we going to reconsider the motion for new trial? And then ultimately, what was necessary in this case was a opportunity to present new evidence on a new and approved claim. And that's where it's kind of a two-pronged due process violation. Is one, we have a due process violation in which the court reconsidered prior rulings without notice and any opportunity to be heard either way. And then secondly, he took the case on the merits and made this positive ruling on a claim that no evidence was ever presented before the court. So first, for reconsidering these rulings, it would have been at a notice that it was going to do that the court was going to take up a reconsideration sua sponte of these prior rulings. And then secondly, also notice of this is the court's taking up sua sponte the merits of the case, or therefore we would have an evidentiary hearing so that Ms. Taylor was given the opportunity to present her new evidence. The record shows that we had new experts, both designated and then treating experts, that were going to talk about this term that I'll talk about in a second, this causal fault, which provides that link between the initial wreck in 2015 and Ms. Taylor's current situation now, including the spinal stimulator surgery and the annular tears, the more significant spinal injuries. Turning to what appellee and defendant argues, they say that Ms. Taylor wasn't prejudiced by this lack of notice or any type of hearing. And how we interpret that brief is there were 6 opportunities to be heard on this, again, statement of quote unquote causal fault, which I have not found a definition in Kansas law on what like causal fault means. I know there's one for fault. There's a PIC instruction for that. The causal fault, I don't think that has a definition under Kansas law that's explicit. All 6 of those opportunities to be heard that appellant or defendant points to are distinguishable because the case in 2024 is completely different than it was in 2020, and then at each stage therefore, and also under a different burden of proof. For example, when plaintiff moved for a partial summary judgment, that was under a different burden of proof than if this case would have proceeded to a trial on the merits.
Can you highlight what the differences would have been between trial 1 and trial 2? So for example, I noticed new experts, new claim. Something that stuck out to me was the treatment of Dr. Wood's testimony. So it's considered in the first trial, then the court says, no, didn't get an opportunity to cross-examine on impeachment. And then he strikes them all together, but then the court goes back and relies on the first trial as an advisory opinion. So can you just compare for us what would have been different about the second trial?
Yes, Your Honor. And do you want me to compare before the judgment where Dr. Wood was excluded, or would you like that
Yes.
to be? Okay, so in the first trial, there was no evidence presented about the spinal stimulator surgery. That had just occurred and there was no records, there was no treating physician or expert to talk about that. Dr. Lane also has been treating plaintiffs throughout the entirety of this time period from 2015 to now. She would have provided a bridge between her status on 2015, sorry, my numbers are getting a little mixed up, and now in 2025 or 2024 when we were set for trial. Moreover, we would have had those treaters who were designated for the second trial that did not testify in the first. And there is a material difference that we would submit in terms of evidence through a treating non-retained physician and a retained physician. But Dr. Lane is the key evidence from plaintiff that would have been different and would have linked everything together. And that evidence was never brought before the court. Moreover, prior to the reconsideration of the motion to strike Dr. Wood, there was a Dr. McAllister that had been redesignated by defendants. He would have been cross-examined during court, and we would have also had that admission from him that, yeah, there was some measure of damage. There was some injury that was caused by that 2015 wreck that we are here today to talk about. Is that at the second trial, it would have been uncontroverted that defendant appellee was negligent. And that was the admissions that counsel made, the vicarious finding admissions that counsel made. And two, that such negligence caused Ms. Taylor some measure of injury. The issue was truly the nature and extent of these damages. They disagreed that their wreck caused annular tears. They disagreed about the efficacy of a spinal cord stimulator. They said these major injuries were attributed to degenerative disc issues.
Right.
Those things would have been linked all up by Dr. Lane. You know, we would have made arguments about eggshell plaintiff, the aggravation and exasperation of pre-existing.
And why weren't those made in the first trial?
Those were made in the first trial, but Dr. Lane's evidence was not presented in the first trial. So there would have been a material difference in evidence. And we're not asking this court to reweigh evidence, reweigh any of the arguments that counsel had made. We're just simply on the second point, which is that the judgment was clearly erroneous, asking the court to apply the law to the vicarious statements of defendant through counsel and the legal effects of those.
Just assuming for the sake of argument that we reverse and remand this case, do you have any position on whether or not it should go back to the same judge?
Your Honor, we would suggest that it goes to a different judge. And I think procedurally, the questions would be, would this court designate it to a different judge, or would we have to then move subsequently for a change of judge upon remand?
Mm-hmm. Okay. You're going to start into your rebuttal time. You've got about a minute to sum it up if you want. You still have your rebuttal time, but
I'll reserve for my rebuttal time.
do you guys have any other questions? Okay, thank you. Mr. Hoffer.
Counsel, let me begin with a question.
Okay.
I usually don't have to ask this question, but was this case disposed of in district court by trial or summary judgment?
There was no summary judgment granted. It was disposed of by a jury trial.
So he set aside the first verdict, but then he vacated that and somehow accepted the first verdict as an advisory opinion.
There was a jury trial, and then there was a judgment and an appeal, and or a motion for new trial, and he granted the motion for new trial.
And then after he found out he was going to have to do a bench trial, he set that aside.
He vacated the order granting a new trial, which is really important for the two questions that were just asked. This is really crucial to understand.
But then he vacated the order for new trial, but he accepted the first verdict as some sort of an advisory opinion. Is that right?
Well, he said that that's what he did, But what we have here is after he vacated his order for a new trial, which is really important because of the questions that were asked, there's no right to trial number 2, right? He vacated his order granting trial number 2. So.
And what
all this-
notice was given that he was going to do that?
I'm sorry?
And what notice was given that he was going to do
Didn't have
that?
to give any notice, any due process notice or anything, and here's why. Is because there was full briefing, full oral argument on the motion for new trial. And you'll note that in their briefing, they don't say what arguments they would have made that would have been new had they been given a second opportunity to argue that. But this notion that they were denied due process for not being given some notice about this court taking up the interlocutory order for a new trial, we really need to look closely at that. The record shows this, and our briefing shows this. They filed a brief, we filed a response, they filed a reply, and there was extensive, intense oral argument on that motion for new trial. So it was fully argued.
I could understand all of that if he would have just said the first verdict stands. But no, then he says that was an advisory opinion, and then he goes on to make a ruling.
Okay.
He looks at all the evidence himself and makes a ruling and granted judgment based on that.
May or may not have, but what happened during that period of time, we have to appreciate that what this is a trial judge still maintaining control of the trial. He hasn't entered a final judgment yet. He's got a jury verdict. And what he's doing, when Your Honor says he goes back and looks at all the evidence, maybe he did, maybe he didn't. One thing we know that he looked at was he concentrated in granting the new trial order originally on the scope of a defense expert, Dr. Wood. And because he knew now he was going to be sitting as the fact finder and weighing the evidence, and he had heard the offer of proof on Dr. Wood, so he knew the full scope of what Dr. Wood's testimony was.
Didn't he exclude, he ends up excluding Dr. Wood.
But he vacated that order as well.
So in one breath, the trial court says, and he's very verbal about all the reasons Dr. Wood's, expert testimony should not be considered. But then he actually goes back and considers it. And how do we?
He does, purportedly. But one thing I want to emphasize too is we're an abuse of discretion standard of review. And that's one of the things I wanted to talk about because we have.
Are we supposed to just ignore the judge's comments that he made on the record, such as, gosh, I don't want to do this trial. I don't want to have to do all this work and write a memorandum opinion.
Sure, but they're not controlling, and you can consider those if you want. But what we do need to do is give deference to this trial judge under either an abuse. I think this is in an abuse of discretion standard of review, or possibly even clearly erroneous when he actually goes and enters his judgment. But you have a trial judge that is still in control of this trial and its outcome and the judgment.
Let me ask you this. So this thing is on the road to a second jury trial, and there's a series of pretrial hearings, and you have this pretrial motions hearing, and the parties reach, I think it was a Glenn B. Fleming agreement, and says, hey, we're not going to go to jury trial because we've reached this agreement. And the parties did that because they thought they were getting a bench trial, and they didn't get a bench trial. So how does the plaintiff receive due notice? The reason they gave up the right to the jury trial was they thought they were getting a bench trial, and then they didn't get a bench trial.
Well, how we got here is important to answer that question too, because we were all proceeding, and then the plaintiff made a very aggressive Glenn B. Fleming demand and said, we are demanding that in order to give your client defendant any protection, you have to agree to waive a jury trial. And that was a strategy decision that the plaintiff made, which now they're here complaining about, by the way, but they made that strategic decision. And that's how we got to the point where we've waived a jury trial.
Is it a valid waiver when they didn't get the bench trial?
Trial court found that it was, and that's an abuse of discretion standard as well. But that's what happened. And so when the jury trial was waived and we're sitting there with an interlocutory order for new trial, the judge said, I'm going to go back and I'm going to revisit my new trial order under an abuse of discretion standard here. And he's going to say there, and he says there's no reason for it. And so he vacates his order for a new trial. So there is no right to a new trial. This notion of we were denied our due process, there's no right to a notice and an opportunity to be heard in the context of a new trial. What they're really saying in their due process argument is we wanted notice and an opportunity to argue again about the new trial motion. And there's no prejudice and there was no right to notice and no due process violation, because you can see from the record, both parties extensively briefed that and they appeared for intense oral argument on that issue. And they don't put in their brief anywhere, because they can't, what they would have argued or asserted differently had they been given the right to a second argument on the new trial motion. It was interlocutory. The trial judge, the district court, was well within its rights to revisit that order and vacate it.
So the decision to revisit the order, how do we review that? Do we review that under an abuse of discretion, or are we? Yes.
That is an abuse of discretion. And here's where we are on the standard of review, because I honestly, I don't think it was really tightly briefed in either brief. It's a mixed standard of review. The only thing that's de novo here is whether there's a due process violation. First of all, they didn't preserve that on appeal. The exception doesn't apply. And there's no due process right to a second trial. It was vacated and they were fully heard on the new trial motion the first time. So, but the mixed standard of review is that's the only de novo review. You would have abuse of discretion for his ruling on the new trial and whether he would receive or not receive evidence, such as if he's reviewing again, Dr. Wood, that would be abuse of discretion. But then what he ultimately does when he finds there was no fault, there was no causation, and there should be a verdict for a defendant, that is even a more strict deferential review of clearly erroneous and due to lack of substantial competent evidence. And I would suggest the court can't touch those things.
Let me back up for a minute. What is our standard of review, in your opinion, on the decision to reconsider basically the reconsideration decision he made to go back and reinstate the jury verdict? Is that an abuse of discretion standard?
Discretion.
Okay, and based on what's on the record regarding what the judge said about all of this, give me your best argument as to why that wasn't an absolutely arbitrary and unreasonable decision.
Why it wasn't an arbitrary and unreasonable decision.
Yeah, because that's one of the three. It may not be an error of fact. It may not be an error of law, but why isn't that arbitrary?
Sure. And we can take these comments that they put in their brief. The judge had a lot of commentary and they picked and chose a few and are trying.
And I think we've read most of them, and it's
right.
not pretty.
So, but no, and here's the thing. So what he did is he sat through a multi-day trial. He heard every witness. He heard unbelievable amounts of intense argument on all the issues that are being complained of from a due process perspective. He ruled against them every single step of the way. He also, with respect to Dr. Wood, the only reason that he was granting a new trial, heard an offer of proof on Dr. Wood, which the plaintiff did what they were supposed to do. They said, here's what we would do if you were giving us an opportunity to present additional impeachment evidence. And so this judge heard 100% of the evidence. And in fact, in getting ready for trial number 2, before the order was vacated, the parties filed their pretrial orders, their pretrial questionnaires, and they were identical other than 2 things, which they want to talk about, which is we were going to put in more medical bills that were incurred since trial number 1. And we were also going to call this Dr. Lane.
I'm not asking about the evidence. I'm asking about the fact that he decided, once he decided that this was going to be a bench trial, I mean, it becomes pretty clear he didn't want to do a bench trial. And so his reaction was, well, then I'm just going to reinstate the verdict, basically. Why was that not unreasonable, given his statements as to why he was doing it? Because he was frustrated and didn't want to have to do this. And maybe I'll just send it back to Judge Hauber. And
sure. And I appreciate it. And I read all that stuff too, but I would suggest that under an abuse of discretion standard, is this court now going to reverse based on some comments from the trial judge?
how else do we determine whether a decision is I mean, we can easily determine if it's a error of fact or an error of law. How else do we determine whether a decision was arbitrary, except by looking at the record and looking at what the judge said when he made his decision.
Right, exactly right. And you can do that under an abuse of discretion standard, but to complete my answer to the previous question, and my comment about the evidence was because to show what he didn't just adopt the jury's verdict. He said it's advisory, and he weighed all of the evidence that he heard. There was going to be nothing new, and he entered judgment finding, as the trier of fact, that there was no fault, just like the jury found, that there's
How was he the trier of fact at that point if he was reinstating the jury
He
verdict?
doesn't have to be a trier of fact. I mean, he was going to be if there was a bench trial, but because the new trial order was vacated, he's not sitting there necessarily as a trier of fact, but he is a trial judge still in control of the judgment that had not been entered yet. It's just like what happens all the time. You get a jury verdict and there are post-trial motions, and you have lawyers come in and argue what the evidence was or wasn't, and the trial judge at that point then evaluates the evidence that came in to see if it supports the verdict. And that's what he was doing as the trial judge, still in control of the judgment. He had the jury's verdict, which he's now considering to be advisory. He has the offer of proof, and he's saying, does the evidence that I'm looking at, me being in control of the judgment, does the evidence support what the jury did? And he's just deciding that it is, not just on one point, but on 3 points.
Let me stop you though. So his opinion changes. So shortly after the verdict, he has a hearing in October 2021, and he's discussing the verdict. And he says, and I quote, "There wasn't a case for judgment as a matter of law either way. The fact that there was some injury appears to have been uncontroverted. The defendant admitted to being negligent." And then today we're looking at his new order where he says the exact opposite. So what is he basing his decision on?
Yeah, I don't think, with due respect, I don't think he's saying the exact opposite. On the thing with the injury, there has to be substantial injury. It can't just be, I twisted my finger and it'll be okay tomorrow. There has to be substantial injury. But even if you think that wasn't proper, he's still found on 2 other elements that would have disposed of this case: fault and lack of causation. And that's exactly what he did. And all he's doing is saying this jury verdict was appropriate. It's still appropriate to enter judgment in favor of the defendant. And so I'm going to do that because I heard a week's worth of evidence and I heard all the argument. And he's entitled to do that because he's a trial judge still in control of his judgment.
He pretty much trashed Dr. Wood's testimony the first time around. And then he said, Dr. Woods testifies, his opinion's the same no matter what the facts are.
He did.
And then he decided, well, I think I'll accept that opinion after all.
He did. He says a lot of that both ways, and I can understand why they focused on that. And I can understand your question. But what I would encourage the court to realize is that you are in an abuse of discretion review when you get to that. And you're probably even in a more heightened review of clearly erroneous, because what he's doing is he's looking at the evidence and he's making his decision. Is there no fault? There's no damage to either vehicle. She wasn't injured.
Right. The whole issue is the extent of the injuries and were they caused by the accident or was some of this pre-existing?
Looking at this as a trial judge still in control of the judgment, and he's saying, I heard all this evidence that supports this judgment. I'm going to enter this judgment. And certainly when he says, no, the evidence does not support a finding of fault, is where he said the plaintiff didn't carry their burden, and there's no causation. Setting aside the damage issue for a second, that is a clearly erroneous standard review. And based on the briefing and what you've heard, whether we dislike his comments, picked and chosen from a week-long transcript, and I get it. I didn't like it when I read it either, to be honest with you. But could this court set aside that judgment on a clearly erroneous standard of review because he said a distasteful thing or two along the way? Not even close.
I'll ask the same question I asked of your opposing counsel. If we were to remand this and send it back, you think we should send it to a different judge?
I don't think you have a choice. I mean, to be honestly, I didn't look at that. I think their opportunity for a change of judge is gone. And we need to, again, look at how we got here. This was it was a strategic decision that they made, because when the jury returned a defense verdict, which surprised them, no vehicle damage, no injury, not a big surprise to me, but when the jury returned that verdict, they thought, because they got a lot of favorable rulings from this judge throughout the trial, they thought, I'm assuming, they thought, if we don't go through a bench trial and we submit this to this judge, he's going to give us a verdict. So they made a strategic decision to do this. It's really difficult for me to stand here now and hear them complain when this was a strategy decision under a Glenn v. Fleming agreement to try to put this in the hands of the judge. And when they put it in the hands of the judge, they don't like his outcome. They're going to pick on a couple things that he said. They're going to claim due process when they didn't even preserve it below. And there's no due process because they were heard about everything along the way. And all of this notion in the briefing about, well, we were going to put in new medical bills and we were going to get a new expert to tie this together. We need to realize there was no new trial right. That was vacated. They didn't appeal that. I have a lot of other things that I could say, but I suspect I'm out of time.
Yes, you are.
All right.
Any other questions for the panel? Okay.
Thank you.
Thank you.
You have 3 minutes.
Thank you.
Will you address preservation, please?
Yes, Your Honor. So under Rule 602, we have to provide an explanation of why this is preserved for appeal. And we would suggest that because we bring a constitutional challenge and that this court must hear these issues to prevent the deprivation of Ms. Taylor's fundamental due process rights. This is squarely before the court and also squarely within the recognized exception to the general rule that you have to bring things up at the trial court level unless it's necessary to serve the ends of justice and also to preserve or to prevent the denial of a fundamental right.
Well, the only way you could have brought it up would have been to file a motion for reconsideration, because you got the surprise January ruling, as you say. The only way you could have raised due process would be to file a motion for reconsideration, which you didn't do, correct?
Correct, Your Honor. But that, because this is a due process issue, and necessarily as well, we're talking about the scope of judicial authority, which has not been addressed by appellee. That's why this should be a null and void judgment and therefore remanded and sent to a new judge for trial. Moreover, we spoke a lot about the standard of review. Plaintiff and appellant believes that both issues are de novo. First, because the deprivation of due process is a constitutional right. This court's review of constitutional claims is de novo. Second, the issue that appellant has brought about the clearly erroneous judgment is that just purely based on the admitted facts on the binding vicarious admissions from counsel, that establishes each element of a negligence cause of action. So we're asking for merely a pure legal conclusion on those things. And necessarily, all of this is to say we have a situation where certainly the evidence shows that the judgment was issued arbitrarily, capriciously, and arguably based on either bias, disdain, or prejudice against bench trials, this case, or plaintiff. For these reasons, we would ask that this court reverse the January 17th, 2024 surprise judgment, which I'm not even sure what to call because the appellee said he wasn't a fact finder. This wasn't summary judgment. I don't know what this is. I don't know where the authority to do that is. And like appellant's counsel discussed, in post-trial motions, we have statutes. There's authority to make post-trial motions. I don't know if this judge had the authority to do what it did here, and I don't even know what to call it, which has led to some of the issues in terms of what is the standard of review for this type of judgment, because it's not a summary judgment. It's just judgment. Therefore, it should be considered null and void because it was an exercise of extrajudicial power that we don't have here in Kansas and could lead to a parade of horribles that we mentioned on my opening argument.
You're out of time.
Thank you,
So,
Your Honor.
Any other questions from the panel?
No.
Thank you very much. Thank you very much. We'll take this matter under advisement.